Great. So it looks like we're good to go.
Yes, hi. I am unfortunately not finding the control showing up on the slide. Apologies, technical details will be right with you. Yeah, it's not working. Okay, so I'll tell you what, why don't you go ahead and control the slides and I'll just let you know when I need them changed.
Sure, sounds good.
Okay, hi, I'm Lynne Graybeal.
And I'm Colleen Ganin.
We'd like to thank the Association of Art Museum Curators for hosting this video presentation and for making it possible for all of us to get together today. We're very excited about being here and hope you're all have had a good morning. Please note that all viewpoints expressed in this presentation are those of the individual speakers and do not reflect the opinions or viewpoints of the AAMC or the AAMC Foundation. Next slide, please. Colleen and I both represent art collectors and have worked on many transactions involving the acquisition, sale, lending, and gifting of artwork. We're speaking with you today from a collector's perspective, and our presentation will cover the following topics: the pros and cons of lending from the lender's perspective, the key provisions of an art loan agreement, the museum form, and the drawbacks of the typical museum form for lenders. We're also going to cover some copyright issues, including copyright basics and the use of images of a work with respect or as part of the publicity and promotion of a exhibition. And we also will talk, if we have time at the end, about moving to a more workable form, but we will work those issues into the discussion as well as we go along. Our talk today should not be taken as a criticism of museums, but rather as an explanation of why the typical museum form loan agreement often doesn't work well for a collector. So from the lender's perspective, there are of course benefits and drawbacks for lending their artwork. Often the lender is interested in supporting the institution and sharing their work with the public. There may be both social and emotional benefits to sharing their work in terms of prestige and in viewpoint of the importance of work, of a particular work. Sharing the work may increase the fair market value through its exposure. There may also be some tax benefits as well as the lender may be able to save on some storage fees if for some reason the work was not otherwise exhibited, or they didn't have room to otherwise exhibit it in another space. But there are significant drawbacks. Some of them are obvious and some of them are a little less obvious. Theft, of course, and other types of damage to the work. There could be third-party legal claims against both the lender and the work. There could be other legal risks. Sometimes the negotiation of the loan agreement is expensive and results in significant legal fees. In an international exhibition, there can be the risk of seizure of the work. And there are often additional risks that are associated with a traveling or multi-venue exhibit. Historically, the art industry has based its relationships on trust. And often when the parties are in their initial excitement of talking about an exhibition, and even through the contracting stage, there really isn't any expectation by either party that there could be any problems or issues down the road. This expectation of trust can inhibit the discussion of contract terms and attempts to manage the lender's risk, because the representing borrowing institution may take it personally, the representative may take it personally if there's a suggestion that a work may be improperly handled. This presentation doesn't suggest in any way that borrowing institutions are mishandling work or taking unnecessary risks with loaned work. But we all know that bad things can happen even with the best of intentions. And often the initial expectation in the discussion is for both the collector to trust the museum as well as bear all the significant risk or majority of the risk of the loan. And what this typically means is that the drawbacks that are listed on this slide for the lender are not often adequately addressed in the loan agreement. Sometimes this issue doesn't come up because the lender simply signs the agreement, perhaps doesn't talk to or work with an attorney, or perhaps their art advisor doesn't bring these issues to the forefront in discussing the loan. But in our experience, whenever we receive one of these form agreements, there are many issues that need to be addressed. And in particular, the agreement is often one-sided. There's often a significant disconnect between the agreement and the museum's verbal and written offer. And in my experience, what frequently happens is that we get a copy of the agreement and the art advisor or the lender doesn't provide us with a letter until after we've asked a number of questions, and then the letter appears. And the letter, which is often very nice and sometimes relatively favorable to the lender, is not reflected in the terms of the agreement that has been provided. It's understandable in a lot of instances because, of course, the form loan agreement isn't coming from your legal department or your outside legal counsel. It's coming from often a curator or curation department. And the museum has specifically had a form drafted that will be that will protect it in a variety of instances. It's kind of a one-size-fits-all form. But often this means that the lender's asked to make promises they can't legally make, that their risks are not really adequately addressed. And the result is that particularly risk is often, rather than balanced between the parties as they can best manage it, it is borne almost entirely by the lender. So these are the typical issues that we are almost always negotiating whenever we are working for a lender in reviewing and negotiating an agreement with a museum. And they include, we've tried to group them here sort of in terms of categories. The exhibition logistics, you can often find pieces of the exhibition logistics throughout a document, but it's often not pulled together in a manner that the lender can fully understand what the exhibition plan is. Almost never have I seen a facility report initially offered. Almost always have to ask for it. And the facility report is important because it allows the lender to evaluate the museum space and its appropriateness for the particular work that's being lent. Sometimes the duration of the loan is either vague or too specific. There often is no obligation of the museum to actually include the work in an exhibition. Usually a museum provides for, the forum provides for the museum to have the ability to withdraw the work from an exhibition. And most of the time that's not unreasonable, but there are instances, particularly when a lender is lending for tax benefits of avoiding sales or use tax, that having the work in an exhibition is necessary for them to achieve that benefit. And sometimes additional security needs to be negotiated for particular work. Risk of loss is a big area that we'll talk about, and that risk of loss occurs at all stages: shipping and handling, if there's conservation, the use of any experts. Oftentimes the insurance exclusions go beyond what is absolutely necessary, and then there are seizure risks that should be addressed, and often an agreement, even an international one, is silent on these issues. Warranties are always covered because the warranties are usually very unfavorable to the lender and ask the lender oftentimes to warrant against risks that they really can't have no ability to manage, no ability to impact. And then there, sort of along those lines, there are issues related to intellectual property that we will talk about. And then often an agreement doesn't have a force majeure clause, but it really should. I think there's probably no greater time than now than that is apparent. And we'll talk a little bit about force majeure clauses because they're getting a lot of legal attention, not surprisingly, right now. So first thing, the facility report. It's important that the lender have a copy of the facility report. And it really will inform in part what goes into the exhibition plan. And often the agreement doesn't arrive with a specific exhibition plan, but I think it's a very good idea to have a delineated plan that makes it clear what exactly is going to happen with the work, from conservation and repair if it's needed, to any special handling instructions, packing, crating instructions, what the security plan will be if there's one that's going to be in addition to the general security plan for the exhibition. Sometimes there are security devices that are attached to the work. That shouldn't happen unless the lender approves, but there may be instances where the lender does want a security device attached. There should be discussions around how the work will be displayed, whether or not viewers will be able to photograph it, how close they'll be able to stand to it, to look at it, whether or not there'll be a line on the floor or a rope perhaps to keep viewers a certain distance away. Sometimes it's important to the lender as to where and how prominent a work will be included in the exhibition. The presumption, of course, is that the museum will be handling that sort of issue. And so if it's going to be addressed at all, or it's important to the lender, that should be in an exhibition plan. And then one of the things that's interesting about form agreements is they leave it very open-ended as to whether, often anyway, leave it very open-ended as to whether or not there are multiple venues. And multiple venues create additional risk because there's additional transportation, there's additional installation and deinstallation, packaging, and often an expectation that the lender will accept whatever insurance and other provisions that have been negotiated on its behalf by the initiating institution. We've included this Lee Krasner work, mostly, I guess, because it is a good example of a work that is traveling among institutions, required an extensive exhibition plan and negotiation involving how the work would be handled during transportation, during installation at the non-initiating museums, whether the initiating museum would have someone as the primary point of contact for the entire exhibition. And so all of these things should be addressed sort of in one location in an exhibition plan, often a separate document that's an attachment to the museum form. Next slide, please. The duration of a loan sounds fairly simplistic, and oftentimes there aren't any issues with that, but it should be wall to wall or nail to nail, as they say in the insurance world. And oftentimes that's not really clear. The loan agreement should include the possibility that the work won't be immediately returned for a variety of reasons, and ensure that the terms of the agreement cover the entire period in which the agreement is out. Next slide, please. There you go. Outside the possession of the lender. One of the things that is important in a multiple venue traveling exhibition, in my view, in our view, is a single point of contact. Often that is with the initiating museum, even though the initiating museum is often feels that they should be able to rely on the other borrowing institutions to manage from the time of handoff. From the lender's perspective, you want a single point of contact because if there's a problem, often it is the initiating museum that has negotiated the additional venue agreements, and the lender has not had a direct contact with the venues, and then therefore does not have a contact and is not a party directly to a contract with those other venues. And then condition reports, which museums often do, it needs to be very clearly specified, particularly in a traveling exhibition, that there will be condition reports that are done both before and after a work arrives, and immediate reporting to the lender if there are any issues, damage or otherwise that arise from that condition report. This work is Kasama Infinity Mirrors, which was a US and Canadian exhibition that you may be familiar with, and it traveled from 6 locations from the Hirshhorn, which was the initiating museum. It was in Seattle. We had the benefit of seeing it. It was a fantastic exhibit. Went to Los Angeles and Toronto, so there would have been some international seizure issues in Toronto to negotiating the agreement, not that there was any seizure, but of course, but to negotiating the agreement. And then traveled to Cleveland and Atlanta. So that would have been a complicated loan to negotiate, and the ending agreement presumably would have looked very different than the one that was the form agreement that the museum might have started with. Insurance is a very big topic, and we are frequently having discussions in the museum, in the negotiations with the museum about insurance, and there are some traps for the unwary or inexperienced. I think in the museum form agreement that a lender may not be aware of if they haven't had significant experience lending, and that typically includes, although there's a statement of a wall-to-wall or nail-to-nail insurance coverage, it typically excludes any, and the museum's liability typically excludes any handling by third parties. And it's often not absolutely apparent when you read the terms unless you understand what in the possession of the museum means. And from a museum's perspective, they don't mean when it's being, usually don't mean when it's being shipped, if there's conservation or repair. Sometimes there's a third-party installation. So from the lender's perspective, you need to make, the lender needs to make sure that they are contracting with the correct party who's going to provide them with the level of insurance that they're expecting to receive. Often the museum agreement asks the lender to elect between the museum insurance coverage or their own, but doesn't provide for the lender to elect both. And we always negotiate that term because it's appropriate for the lender to maintain its insurance while the museum also maintains insurance for the exhibition and specifically for the piece being loaned. And the lender should be a named insured on the museum's fine arts policy. And the insurance exclusion should be very limited. One of the points that we've recently negotiated is the elimination of an exclusion for terrorism or damage from people acting from a political motive. This is a coverable, insurance can be obtained for that sort of damage, and so we have an expectation that that will not be excluded from the museum fine arts policy that covers the work. But oftentimes there are more exclusions in the form agreement than are really required or that are needed because the museum has coverage for certain things that sometimes are not included or excluded in the insurance provision. Again, on a traveling exhibition, the lender wants a single point of contact. And while it may not be possible for the lender to get the museum to agree that they will provide insurance as the piece travels to other locations, we typically are negotiating that there will be a single point of contact at that initiating museum that is required to be making the museum responsible, even if not under insurance coverage, for ensuring that the museums that are part of the tour are complying with the various terms that have been agreed to in the exhibition plan. Seizure is a really important topic if it's an international exhibition. The lender needs to be confident that its work won't be seized if it travels to another country. Many countries grant immunity from seizure while artwork is on loan. The immunity is, of course, desirable because it operates as a safeguard for the lender to ensure that if the lender has a creditor, the creditor won't be able to attach the work to satisfy a loan, or another party won't be able to contest the ownership of that work while it's traveling. There should be in the agreement a provision requiring the museum to apply for immunity for seizure and to comply with all of the obligations that are necessary to receive that grant of immunity from each of the jurisdictions in which the exhibition is going to travel. There are a number of countries that have laws providing immunity from seizure, but there are also a number that don't. A handful that do are the US and Canada in some of its provinces, but not all. The United Kingdom, France, Switzerland, Belgium, Austria, Germany, Israel, Russia, Australia, New Zealand, and Japan. But that issue should be looked into for the specific jurisdictions whenever there's a traveling exhibit to other countries. Next slide, please. I want to cover a little bit on lender warranties, and then Colleen will cover this as well. But the lender is often asked to provide a warranty and indemnification for topics that they're really not in a position to provide those warranties and indemnification. And often this is an area of both negotiation and misunderstanding. The museum form agreement frequently asks the lender to take on risks that it can't manage against. And again, if you think about risk, it's really a balancing of who should be responsible for what type of risk. And typically it is the party who is in the best position to either prevent the loss from happening in the first place or insure against that. So for example, often a form agreement will ask the lender if they will provide an image of the work, if the museum can use an image of the work, and then ask the lender to provide a copyright indemnification for the lender's, for the museum's use of that image. And as you will see, the lender is really not in a position to provide that because the lender is almost never the copyright owner. Appropriate warranties and indemnifications for the lender are really relate more to the work. The work is unencumbered, that there aren't any liens, that there isn't any reason that the lender, any contract that the lender has entered into that would prevent them from entering into the loan with the museum, that the provenance that the lender is providing to the museum is accurate and complete to the best of the lender's knowledge, and that the work is suitable for travel and exhibition. It's not so fragile that it will fall apart when created or when installed or traveling to multiple locations if it's a multi-venue loan. So let's talk briefly about force majeure, because this is a topic that is sort of a mundane, usually part of contract boilerplate. People don't really think too much about, often not included at all in a loan agreement. But force majeure is getting a lot of attention right now because of the COVID-19 pandemic. The lack of inclusion of a force majeure provision in form agreements as well as negotiated agreements needs to be revisited. And the reason is that if there is no force majeure provision in an agreement, the parties are still required to act even when they physically can't, or even when it's so commercially unreasonably expensive that it just isn't reasonable to act. In my experience, my recent experience related to COVID-19, I think both lenders and museums are being very reasonable in their actions, but from a legal standpoint, one or both parties typically isn't very well protected. So we are currently recommending the inclusion of force majeure provisions in loan agreements, other art-related agreements. But it's also important to know that that may not be a complete answer, because your museum contract is probably governed by the law of the state in which your museum resides. And therefore, it's necessary to look at the state law of a particular jurisdiction to interpret force majeure clauses, because they are interpreted on a state basis. So for example, in New York interprets force majeure provisions very narrowly and requires the listing of specific triggering events, and also requires that the triggering event that the parties are relying on, one or both parties are relying on, may be unforeseeable. That's an interesting challenge at this point, because although many force majeure provisions are being drafted to include pandemics as a triggering event, it's very questionable at this point whether COVID-19 would be considered unforeseen. In California interprets things much more broadly and more favorably generally, which isn't too surprising. That's California law tends to be that way. And parties invoking a force majeure clause must show that in spite of skill, diligence, and good faith on the parties invoking the clause's part, the performance became impossible or unreasonably expensive. So that doesn't require a specific triggering event or the listing of a specific triggering event. It also doesn't require the event to be unforeseeable. Our recommendations at this point are to both provide force majeure clauses. Colleen, you want to go to the next slide, please? Thank you. Within contracts, specifically listing triggering events, but also to provide a provision discussing how the exhibition and the artwork will be handled in the event of a pandemic outside a force majeure clause if force majeure does not apply. And the parties in the negotiations should consider their remedies based on their relationship, and that could include termination of the contract, excusing certain obligations of performance under the contract, permitting a delay, an extension of the loan, and addressing storage and security issues during the force majeure or pandemic event. We want to spend some time on copyright and intellectual property. It's a very important topic. It comes up somewhat incidentally in form loan agreements, but it's a very important issue and one that should be resolved in any loan agreement negotiation. So as I said earlier, unless the lender is the artist or their estate, they almost never own the copyright in the work that they're lending. Now, it's also possible that there might not be copyright if the work is old enough, and Colleen will talk a little bit about that. But for any modern work, the copyright is most likely not owned by the lender. But the museum often wants to use an image of the work, asks for permission to use an image of the work in a variety of ways, and then expects an indemnification from the lender for those uses. And the lender's really not in a position to give that indemnification. And in fact, it really is more reasonable for the lender to ask the museum to not only seek permission for use of the image, but to indemnify the lender for copyright claims, should there be any, based on the museum's use. This slide shows a couple of items from a gift shop from the Museum of Cultures in Milan, Italy. Banksy sued the Milan Museum for trademark infringement for unauthorized use of these images. Interestingly, his claim didn't include copyright, although it certainly could have. And he has been quoted as saying that copyright is for losers, but I would suspect that most copyright owners do not feel that way. In this instance, the judge ruled that the museum had to remove all of the unauthorized works from the gift shop. However, the judge did provide that the images could be used as part of the marketing and promotional materials for the exhibition. So really that speaks to, although it isn't it speaks to the different types of uses that images can be made of, and there's a legal analysis as to whether some of those are more risky than others that Colleen will discuss. So I'm going to turn this over to Colleen and let her talk with you about copyright.
Can you hear me? I think I
Yes.
was muted there for a second.
Yeah.
So we thought it might be helpful. Thank you so much, Lynn. So we thought it might be helpful to have a little sidebar on copyright basics, which I'm sure, as Lynn mentioned, we encounter sort of incidentally in the negotiation of art loan agreements, but we're sure you encounter pretty regularly in the context of your work in the art lending context and just the art world in general. So as you likely know, copyright is a legal term which refers to an artist's bundle of rights in a work. That bundle of rights includes the exclusive power to reproduce the work, so make copies of the work, distribute copies of the work, publicly display the work, perform the work, create derivative works based off the works. So that would be, trying to think of a practical example of that. We'll get into that a little bit later. And then finally, to prevent destruction, mutilation, or modification of the work. And that's what's referred to as moral rights. So copyrights don't last forever. And after a certain period of time, an artist's copyright expires. And once a copyright expires, the work enters what's called the public domain. The public domain refers to creative materials that are not protected by intellectual property laws. So typically, a work of art would enter the public domain when the copyright expires, or sometimes we'll see artists forfeit their copyright in their creative work and just sort of allow the public to own it. And the public domain would also refer to unprotectable subject matter. So creative items that aren't covered by copyright law, including facts, recipes, familiar symbols, etc. I'll caveat that by saying that it's not always an easy analysis as to whether something is protectable or not, but that's for a different presentation. And if a work is in the public domain, you can really do whatever you want with it. The public owns these works. They're no longer owned by an author or an artist, so anyone can use the public domain works without obtaining permission. No one can ever own them. And this also means that you can make, you can make derivative works based on works in the public domain. So for example, as you can see here, Jonathan Lewis's She's a Model and She's Looking Good is a derivative work of the Mona Lisa. And Daniel Warnicki's Van Gogh Self-Conflict is a derivative work of several Van Gogh self-portraits. So the flip side is, if a work is covered by copyright, if it's not in the public domain, then you need the copyright holder's permission to use it in any real capacity. I think that's just the general rule. We'll get into some sort of unique exceptions to that, but in general, if you reproduce artwork without the copyright owner's permission to do it, permission to make the reproduction, then that would be considered copyright infringement. And so this image here relates to a case called Ferry v. Associated Press, and that is a case that is sort of an interesting illustration of this notion. In that case, the Associated Press alleged that street artist Shepard Fairey's hope posters that were largely promoted and used during the 2008 Obama presidential campaign, infringed on the Associated Press's copyrighted photo shown here. In 2011, after years and countless thousands of dollars in legal fees, the case settled out of court, but presumably that all could have been avoided had there been a discussion at the onset. So the question is, how do I know if a work is in the public domain? And the answer will involve calculating the duration of the work's copyright, which varies depending on a variety of factors, including when was the work created, whether the work was published or not, which publication means, just as an aside, whether the author has made the work available to the public on an unrestricted basis. Some other factors that will impact the calculation of the duration is whether it was created by an individual or a business, i.e. a work for hire, or if certain forms of copyrighted works are also have unique copyright duration calculation issues. So as you can see by this chart, calculating copyright duration is very complicated. And just as an aside, this is actually a simplified summary of copyright duration in the United States, sort of the calculation process. The reason why it's so complex is because there have been several legislations passed over the years to extend copyright protection for older works, which has added on layers of increased complexity to the copyright duration scheme in the US. And so that's, the prior slide actually only contemplates US copyright. Of course, other, other nations worldwide also have their own unique copyright schemes and their own unique durations for their copyright protection. So this is, we won't dive into this, but it's sort of a helpful illustration and a simplified map showing what copyright, how copyright is protected abroad and what the duration generally looks like. So say that you want to use an artwork that is not in the public domain. The question is, can you ever use it without permission from the copyright owner? And for our purposes, we would say there are, but they're very limited. And in particular, a copyrighted work can be used without the copyright holder's permission if it qualifies as what's called a fair use. I'm sure most of you have heard of this term before. Generally, a fair use would be use of a copyrighted work for criticism, so criticizing the work or the artist to a lesser extent, to comment on the work, so a discussion of the work, news reporting, in the teaching or scholarly context, or in research. And importantly, fair use is a defense to infringement. And this is important because a copyright owner would still have standing to raise a copyright infringement claim against the fair user in court. They just wouldn't necessarily be successful in that claim. So this would be an issue that a judge typically decides. So in terms of a practical considerations, fair use, as I said, it is a defense to infringement, but that doesn't mean that you won't be, encountering or incurring legal fees in asserting the fair use defense. So in evaluating whether a use is quote unquote fair, courts consider 4 primary factors. The first is the purpose and character of the use. That would be, is it educational? Is it commercial in nature? Is it a parody? Is it criticizing the work? The second is the nature of the copyrighted work. So the more creative the work, the more likely this factor will weigh against fair use. The amount and substantiality of the work used, and the effect on the market for licensing the work and the value of the work. So not all factors need to weigh in favor of a museum to qualify as fair use, but we just want to emphasize that this is a very specific, a very fact-specific inquiry, and there are no bright line rules or guidelines from Congress or courts guaranteeing that any specific use will fall within the defense. So we recommend always erring on the side of getting permission from the copyright owner. So to illustrate this, we thought we would point to a couple of uses that museums commonly encounter. and sort of just briefly glaze over whether they would constitute fair use. And this is really meant to illustrate that it depends almost in every instance. It is, again, a very fact-specific inquiry. So, you know, we can dive into a couple of factors that help weigh in favor of fair use, but in general, you know, again, we recommend always asking for permission from the copyright owner before using a copyrighted work, or if not, you know, you would want to undertake a fact-specific inquiry yourself before using the work in order to evaluate whether your particular use at hand is fair. So the first one is online collections. To you know, avoid the typical lawyer answer, but this may be a fair use. Use of thumbnail images and used with contextual information will help the argument that it's fair use, but again, it always depends on the various facts at issue. Same with publications. Of course, a copyright or a coffee table book is unlikely to be fair use because that is, you know, it's not necessarily for an educational purpose. It's definitely commercial in nature, given the profit generating portion of that. And then if you're looking at exhibit catalogs, possibly would be fair use, but more likely to be fair use if you're using small images with explanatory text. And then again, promotional materials, you know, promotion of the museum, that's less likely to be fair use as opposed to promotion of an exhibit, use of an image in promotion of an exhibit. And use of a low resolution image is always preferable, and that will always weigh in favor of fair use as opposed to a high resolution. And so here are a couple of really helpful fair use resources that we would recommend you taking a look at. We could probably distribute these after the presentation as well. So Lynn, I'll hand it back over to you.
Thank you, Colleen. So I wanted to make sure the audience is aware, of course, that we're happy to answer questions, and please feel free to include questions in the, you know, as part of the chat function, and we can also look for questions at the end as well. So let's see. So we have covered, I think, all of the key issues that often arise in a negotiation. And we wanted to provide some alternative thoughts in maybe a little bit less legalese sort of format to provide guideline for reconsidering some of the provisions in the form loan agreement. In general, it's important to keep the lender's risks and concerns and really why the lender is lending in mind. We recommend to really short circuit the negotiations by providing a loan agreement that actually reflects what the parties have been talking about in terms of the logistics of the exhibit. And the risks should be really more fairly allocated between the parties. And one of the things that I have found in my negotiations is that very often when we ask for things, the museum will agree. So it isn't that we're asking for something unreasonable or something that the museum legal counsel just can't get behind. It's that the agreements, because they are drafted sort of as a one size fits all, and then at least a frontline negotiation is done by a non-legal person, they often are drafted in a manner that creates additional negotiation and extends the amount of time it takes to put a loan in place. Next slide, please, Colleen. So we created a chart, and we can provide a copy of this chart along with the links that Colleen just mentioned to the copyright resources and that we can have that distributed through the AAMC to the participants. So the first provision relates to the museum not being responsible for the loss caused by third parties. Now, often the museum is the one that's recommending the third parties. They use their own trusted advisors. That's not always the case. Sometimes the lender, a very sophisticated lender, has their own conservator. They have their own shipper. And in those instances, it's not at all unreasonable for the lender to work directly with those experts. But in situations where the museum is the one that's taking the lead on conservation, on shipping, on any kind of other third-party services, the agreement should provide that the risk does not shift back to the lender during that time. Typical agreement doesn't require the museum to provide condition reports, and it tends to provide a relatively low degree of care, even though the expectation is that there will be a much higher degree of care. So we often add provisions to the agreement requiring condition reports upon both receipt and departure, and any other major event, installation, deinstallation, if it's being moved between the same museum's venues. Immediate notice of damage, that no repair take place without the approval of the lender, unless, of course, it just is absolutely necessary to preserve the work. And the expectation that the museum will provide a high degree of care. We've talked about insurance. Again, lenders shouldn't be required to select between insurance. It's probably beneficial to both parties that both the lender and the museum carry insurance. The lender should be a named insured on the policy. And the museum should, in naming the insured on the policy, should be prepared to provide a certificate of insurance. Oftentimes, there are no provisions on seizure, but the agreement should provide if the work is being exhibited in another jurisdiction, that the museum apply for and comply with the terms required for immunity, a grant of immunity to be obtained. And also that the museum comply with any export or import laws. We've covered the use of images fairly extensively. Often, again, the obligation to agree to uses of images is put off on the lender when the lender is really not in a position to grant that right. Often the lender it doesn't have any problem whatsoever with the museum using an image. And so it's appropriate, to include that in the agreement. But really it is the lender who should be indemnifying the museum who should be indemnifying the lender in the event of infringement, and it should be the museum's obligation to make the determination about whether or not what they're planning to do requires consent of the copyright holder. I want to make sure we can get to questions. Colleen, do you have any questions? No, you're looking at them right now. It looks like we've now had a number of them come in. We can break. We only have a few minutes left, so we can break for some questions and provide this chart. I don't think it's necessary for me to read through the whole thing. But I do think it's a useful and instructive document to help you when you're negotiating with a lender, understand what the lender's perspective is, what they might be asking for, and maybe consider amending your form agreement to provide for a more balanced approach, particularly when the works are of very high value and the lender is likely to have someone who is wanting to negotiate the agreement for them. So Colleen, I'm going to turn it over to you to ask any questions you think we want to try and address in our last few minutes.
Sure. I lost my chat box, so bear with me.
Oh, okay. Let's see.
Here we go. Sure. So first question for you, Lynn, is can you address insurance values provided by the lender and what the lender's responsibility is for, I guess, supporting the insurance value provided? The concern is that there would be inflated value representations.
Right. We typically, particularly with high value works, I mean, if a work has been recently acquired, then there is a value because you have a purchase price. But if it's not been recently acquired, we typically recommend to our lenders that they seek an appraisal so that their own insurance can be updated before the loan is made. And then that appraised value there would presumably would A, be accepted by the lender's insurer, and then B be done by a certified appraiser, and then would be appropriate for the museum to accept as well. But I agree that you know, just accepting a ballpark from the lender, if the lender is if that's not the appraisal value that's being used by the lender's insurance, it probably is reasonable to question that.
Great. Let's see. So next question for you, Lynn, is should third parties not have their own insurance to cover any damage caused by them, therefore not requiring responsibility from the lender or the museum? So that would be referring to handlers. Shouldn't the handlers have their own insurance, and wouldn't that cover, sort of obviate responsibility for handling any damage that they cause to the work, as opposed to the lender or the museum handling it?
So it's a great question, and conceptually, the handler or the expert should absolutely be carrying their own insurance, and it should be adequate. But the lender is not generally in a position to evaluate that. And as we just discussed in terms of appraisal value and insurance value placed on that work based on the appraisal, the typical transporter or conservator is not necessarily going to be taking out a policy specific to the work, naming the insured, providing an insurance value that is commensurate with the appraisal. And so there's two issues there. From a lender's perspective, it's sort of who knows what the third-party insurance is. The lender may not even know who the third party is or have any ability to contract an agreement with the third party. The museum is actually in the best position often to have that contractual relationship with the third party. And as a result, should be making sure on a general basis that the insurance is adequate from the insurance carried by the expert or vendor is adequate. And there's no reason really why there can't be a cross-insurance relationship also between the vendor and the museum, so that if the museum ends up with liability to the lender, the museum can turn and look to the vendor. But generally it's not reasonable unless the lender is involved in the direct contractual relationship with the third party vendor. It's not reasonable for the lender to be expected to rely on that, because the lender doesn't have any ability to control what kind of insurance or the quality of insurance that the vendor is carrying.
Great. Let's see.
Let's see, do we have any copyright questions?
I see one relating to, does the Louvre have the right to the photograph of the Mona Lisa? So that's an interesting question. So analyzing this under US law, because we wouldn't necessarily be able to contemplate issues arising under EU related copyright laws. But so analyzing this under US law, the creator of a photograph owns the copyright in that photograph to the extent that the photo, and when we're talking about a photograph of an already creative work, their copyright would only be extended to any unique or protectable elements that arise out of the photograph. So if the Louvre were to take a photo of the Mona Lisa that added some sort of unique protectable elements, maybe they put you know, a Snapchat filter on the Mona Lisa, or, you know, make some sort of artistic selection in a filter, add some sort of elements. They would own the rights in the additional elements added to the photo of the Mona Lisa. And I also, you know, if I were to go to the Louvre and take a photo of the Mona Lisa that was sufficiently creative to add additional copyrightable elements, then I would be the owner of the copyright in the photograph to the extent that it has protectable elements in addition to the Mona Lisa. Let's see.
So Colleen, here's a question. If a curator teaches an online art course and uses the thumbnails of artwork, are they liable for infringement?
If they teach
an online art course?
Sure. So it's a good question. There is an exception to there's an explicit exception to or an explicit definition of fair use, and that would be an educational fair use. So assuming that you're actually giving a live webinar with sort of face-to-face sort of instruction, and then you are using these images to supplement, and you are indeed discussing the images and they're sort of illustrating the points that you're making, then it's likely that it would be fair use. But again, it is such a fact-specific inquiry that it's difficult to say without seeing all of the, and I hate to say that because I know that's a very lawyer thing to say, but it is very fact-specific. So to the extent that there could be other facts that would sort of weigh against or mitigate any fair use defense that you would have in that case.
I think it's probably fair to say if the the thumbnail images are being used for purposes of discussing the artwork itself, educating someone about the artwork, teaching or commentary about the artwork, that is likely to be considered a fair use. I do have a question here I'd like to answer about, and for some reason my screen has gone dark. I apologize, I'm not sure why. Hopefully everyone can still see me, but someone asked, you mentioned that COVID might not be considered an unforeseen event in force majeure language. How would you reconcile this with loan agreements and other contracts that were issued before the onset of the pandemic and therefore unforeseen? So to clarify, what I meant when I said that COVID-19 might not be considered an unforeseen event, I meant in the future. So there's a lot of discussion right now in drafting force majeure clauses to take a COVID-19 pandemic type event into consideration in the drafting of new provisions. And depending on the jurisdiction that you're in, that may not fully address the issue, because another global pandemic, we've already been told we may have a resurgence of this one, and another global pandemic is potentially anyway foreseeable in the future, unfortunately. So I'm not talking about existing clauses and existing contracts that happened before the pandemic really took hold. I'm talking about the drafting of future provisions. Let's see.
So I think that looks like we're getting the red flag that our time is up.
So I do have one question here I'd like to answer in general if we have time. It says, what about dealers who sign loan forms on behalf of lenders and don't allow access to the lender themselves? How do you ensure to get the real lender to sign? So I've addressed this issue when our firm often borrows artwork, and we've addressed this issue when we have been the recipient of a loan. And we're happy to work with it's often a gallery, sort of the lender's agent, but we require in our agreement that the agent that they have the authority to represent the artist and to make the commitments in the agreement that the but often we're borrowing from an artist, but it could be someone who's, I guess, a work that's not directly from an artist, but the lender, that the agent has the legal right to contract on behalf of the lender. And then with respect to works that we often are borrowing, we require the lender to sign it as well, that they acknowledge the terms of the agreement. So I think that it depends on, all of these things are a balancing act. If you really, really want or need a work for your exhibition and you simply can't get the lender to sign, then what you want is the agent or representative of the lender to be on the hook for not only the obligations under the agreement, but a representation and warranty that they are legally authorized to make those representations and warranties also for the lender. So I think we are at about our time. Happy to answer another question if just see. Okay, great. Well, we are at our time. It's been wonderful to be able to speak with you today. I hope you enjoy the rest of the conference, and we will be in touch with the AAMC to provide you with some of the resources that we talked about during the presentation. Thank you very much for your time.
Thank you.